The death sentence cannot be executed until confirmed by the High Court. When the accused are sentenced to death, to be hanged by neck until dead. Come, we'll learn with the provisions of law. What are the laws covered? Criminal law, IPC and Evidence Act, where the Sessions Courts of Madurai has convicted 9 accused who are police, wherein the case pertains to custodial death. Coming back to the class, as we will discuss the Sathakulam Custodial Death Case. What is the custodial death case? We will discuss in detail. State CBI versus Sridhar and others. Sessions case number 470 of 2020 and court decided by the Court of First Additional District Sessions Judge Madurai. And judgment was delivered on 23rd March of 2026 and sentence was pronounced on 6/4/2026. And this judgment is translated from Tamil language to English, which came down to around 240 pages from 683 pages Tamil language, and this was translated through AI, and have also extracted this PPT from the entire judgment. So coming back to the what we'll cover in this session and judgment is case background and timeline, the events, the accused, who are the accused, and charges, what are the charges framed, what is the evidence, what are the key legal issues and judgments and precedents, and we'll also discuss the multiple choice questions in short. So parties and the premises. A, who ran a jaggery business under the name Berlin Traders from a rare portion of the shop in Sathakulam, Thoothukudi district in Tamil Nadu. And B, who is the son who ran a mobile shop under the name and style APJ Mobile City from the same premises. And I am not taking the names of accused and the complainants and the victims. So we'll address them as A and B, or police inspector or constable. So what triggered the incident? The incident was happened on 18 June 2020 and the day which triggered the incident. An inspector who was on the COVID-19 patrol duty, where he rebuked the workers who were collecting the daily wages near the market. So he threatened the workers, saying that skin them alive, the term he used, and if at all they were again found at that marketplace. So seeing this incident, the jaggery trader, who is the father, who is the A, I've addressed as A. So he allegedly remarked the policeman who spoke rudely to the workers, and one of the head constable overheard his remarks and informed his colleagues. And keeping in mind, on the very next day of incident, on 19 June 2020 at around 7:30 to 7:45 p.m. the policemen came back because there was a COVID-19 curfew. So the inspector and 2 officers arrived, questioned A and taken him to the police station. So on the next day, what happened? On 18/6, as we discussed, 18/6/2020, A criticizes SI's conduct. On 19/6, he was taken to the Sathakulam PS at 7:45 p.m. And then what happened? On 26/2020, a false case was registered against A and B, father and son, who ran a business, and as A was taken to the police station, B followed, his son followed the police and for inquiring. Thereafter he was also held at the police station. On 26/2020, a crime was registered by number 312 of 2020 against father and son who ran a business in the market. So both were remanded to the Kovilpati sub-jail. Before the and during the incident, both men were tortured by the policemen, and what are the roles of the policemen we will discuss. So on 22/6/2020, B dies, son dies at Kovilpati Government Hospital, and father dies on 23rd June 2020. On the very same day, the Honorable High Court of Madras, on knowing the incident, taken suo motu cognizance on the same day. Then the matter on 7/7/2020, the investigation was transferred to the CBI as the policemen were involved in this crime, and later on 23rd of March 2026, judgment was pronounced and sentence was pronounced on 6/4/2026. In this case, the trial was conducted for a long time because of the many as witnesses, and out of which 52 prosecution witnesses, and there are main key witnesses also examined, which led to the conviction. Next, the night of torture. What happened on the night of torture? So both men stripped and beaten with a wooden lathi on a table at many intervals from 8 p.m. onwards to 2:30 to 3 a.m. in the early morning. So prime accused inspector repeatedly demanded he don't want to hear any sound, so instigated many rounds of beating. And another constable refused to strike blows, but he guarded the door to prevent anyone entering from the main gate. So further, apart from beating and holding in police station illegally, a false complaint was registered as crime number T12 of 2020 at the directions of the inspector to cover up the assault. And later on, both men were medically cleared despite visible injuries, then remanded and transported in a private vehicle to avoid blood stains being noticed. And then on 22 June 2020, B died. B died due to heavy blood loss, and A, father, died following morning on 23rd June 2020. So these are the incidents, and now we'll discuss the role of each accused. Number one, inspector, because I've removed the accused names. So number one, who is the inspector and the prime accused, who is the chief instigator of the crime. He also ordered the false case to be registered against the father and son, and ordered to delete the CCTV footage from the premises. So number two is the sub-inspector, who is the assailant, and he struck the most of the blows. So another one, number three, joined the beating in the plain clothes, and also who is the person who registered the FIR. There are two head constables. Two head constables held the father and son, beaten very seriously. So one of the head constables signed the false complaint as a complainant. Another head constable held and beat them, and he was fled from the incident when later on asked to surrender his lathi. So there are four constables who are the other accused in this crime. So that one of them, all nine were, there are 10 accused. One accused who died during investigation, and that was declared as abated. Further, everyone involved in this incident where two men were tortured and declared dead. So one of the constable helped the CCTV footage to be erased, and there are prime witnesses who watched the incident, and we'll also discuss. what are the charges framed under? Charges will be framed under CRPC. Now BNSS will also discuss the provision under which provision charges will be framed before the court. So all charges are subject to 34 IPC common intention, which is now section 3 subsection 5 of BNS. So first section is, we will discuss in detail all the provisions. Today in this session we will only discuss the IPC Indian Penal Code, which is Bharatiya Nyaya Sanhita. So now confinement, wrongful confinement. Section 342 IPC is defined in the 340 IPC, wrongful confinement. What is wrongful confinement? I will read the provision and discussion related to the case. Wrongful confinement is under BNS is section 127 subsection 2 of BNS, and chapter is of offences affecting the human body. So now first we will read the provision. What is the definition? Wrongful confinement: whoever wrongfully restrains any person in such a manner as to prevent that person from proceedings beyond certain circumscribing limits is said to wrongfully to confine that person. Example, in this case, A and B were taken to the Sathakulam police station and unlawfully held between 8 p.m. to 3:30 a.m. in the morning. Unlawfully, without any valid reasons, without showing proper arrest, without informing what are the reasons of arrest, whether they were arrested legally or illegally, that was decided already. So and unlawful held and illegally confined over several hours. Now in the illustrations we will also read from the Bear Acts also. Illustration A causes Z to go within a walled space and locks Z in. Then Z is thus prevented from proceeding in any direction beyond the circumscribing line of wall. Then it is called A wrongfully confines Z. Now illustration B. A places men with firearms at the outlets of a building and tells Z that they will fire at Z if the Z attempts to leave the building. Then it is called A wrongfully confines Z. So in this case we discussed that A and B were wrongfully taken to the police station. They were held illegally from 8 p.m. to the 3:30 a.m. then followed by the other incidents. They beaten them, they wrongfully confined them, they held between the so and so time. That is where the wrongful confinement occurs. Further, what is the punishment under BNS? Earlier IPC 342 section IPC, now BNS 127 subsection 2, and also read further section 127 subsection 2. So whoever wrongfully confines any person shall be punished with imprisonment of either description for a term which may extend to 1 year, or with fine which may extend to 5,000 rupees, or with both. Further, we will also read the section 127 subsection 3, because one under BNS 127 subsection 1 is definition, what is wrongful confinement, subsection 2 is punishment, subsection 3, whoever wrongfully confines any person for 3 days or more shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine which may extend to 10,000 rupees, or with both. So in this case subsection 2 applied, which was the punishment is of about 1 year, or with fine which may extend to 5,000 rupees. Further, subsection 4, whoever wrongfully confines any person for a 10 days or more shall be punished with imprisonment of either description for a term which may extend to 5 years and shall also liable to fine which shall not less than 10,000 rupees. Subsection 5. Whoever keeps any person in wrongful confinement knowing that a writ for the liberation of that person has been duly issued shall be punished with imprisonment of either description for a term which may extend to 2 years in addition to any term of imprisonment to which he may be liable for under any other section of this chapter shall also liable to be fined. Now, subsection 6, subsection 7, subsection 8 we will also discuss later because of we are only confined to this judgment, and we'll conduct classes in detail. Every section have many important points. We'll also discuss in detail. Now the relevancy of this judgment and section is 127(2) of BNS. Coming back to the wrongful confinement, wherein punishment for wrongful confinement is 1 year and which or with fine which may extend to 5,000 rupees. So we discussed this. A and B were taken to Sathakulam police station and unlawfully held for 8 p.m. to 3:30 a.m. beaten with lathis, and one person deleted the CCTV footage, one person guarded the entire incident, and there are some other witnesses we'll discuss along. So we have read now 342 IPC and 127 to BNS. Which is wrongful confinement. So coming to the next provision, which is 201 IPC, which is 238 BNS, comes under the chapter of false evidence and offences against the public justice. Now 201 238 BNS, we'll go to the 238 BNS. Now 238 BNS, we'll read the entire provision because to understand in detail, as we already discussed, we have to go into the depth of the sea. Unless we go into the depth of the sea and understand the provisions of law, we cannot understand nothing. We'll learn nothing if only we'll read the provisions. I will also each and every provision, whenever we conduct the detailed classes in the future class sessions, then we'll read the sections, understand the provisions one by one. Now in these sessions, as this is a test series, and we'll study in brief also with the judgments, relevant judgments in this case. So coming to the section 238 of BNS, which says causing disappearance of evidence of offence or giving false information to screen the offender. Whoever knowing or having reason to believe that an offence has been committed, causes any evidence of the commission of that offence to disappear with intention of screening the offender from legal punishment, or with that intention gives any information respecting to the offence which he knows or believes to be false, shall A, if the offence which he knows or he believes to have been committed is punishable with death, be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. If the offence is punishable, B, if the offence is punishable with imprisonment for life or with imprisonment which may extend to 10 years, be punished with imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine. C, if the offence is punishable with imprisonment for any term not extending to 10 years, be punished with imprisonment of description provided for the offence for a term which may extend to 1/4 part of the longest term of the imprisonment provided for the offence, or with fine, or with both. So we have read this section 238, causing disappearance of evidence, and what is the relevancy in this case? Relevancy in this case is section 238 BNS is causing disappearance of evidence of an offence. So in this case, there was a CCTV footage and the CCTV footage was erased by the accused. So, erasure of CCTV footage. What evidence was disappeared? What happened on that night? Discarding of blood-stained clothing, failure to seize or preserve the items as evidence, use of a private vehicle to avoid bloodstains being seen. What they have caused, what the accused have caused in this case, they completely cleared the bloodstains. They caused disappearance of the total evidence. They failed to seize or preserve the CCTV footage because all are hand in glove with each other to cover up the crime. They hidden the blood-stained clothes of the victims A and B. So here 238 applies, causing disappearance of evidence of offence or giving false information to screen the offender. And illustration, we'll also read with the examples, illustrations. A, knowing that B has murdered Z, assists B to hide the body with the intention of screening B from punishment. Then A is liable to imprisonment of either description for 7 years and also liable to be fined. And already you have studied in during your law school, whatever offence is punishable more than 7 years is non-bailable, and below 7 years punishment is bailable and triable by so and so magistrate. Will discuss under CRPC what are the provisions, what are the bailable offences, what are the non-bailable offences. And in this case there are ABC subsections under 238, and in this case 201 IPC, which is 238, applies. So coming to the next provision, and there is a common intention, because common intention applies where more than one accused commit one crime with common intention. So it is already you know. We'll also read the section now. Section 3 subsection 5 of BNS: acts done by several persons in furtherance of a common intention of all, each is liable as if act were done by him alone. So next we'll go to the next section, 302 IPC, which is murder, punishment for murder. 103 subsection 1 BNS, read with 34 IPC, common intention. So we'll go to the section 103 subsection 1. This provision will take long time to discuss because we are having many legal points in this to discuss. So for now I am explaining in brief. So we'll go to the 103 BNS. BNS is, and the definition of murder is section 101, murder, A, B, C, D. There are again for every provision having exceptions also. We'll also discuss now. (101) 103 punishment for murder. Definition of murder is given in section 101 BNS. Firstly, we will discuss the definition of murder. What is murder? Except in cases herein after accepted, culpable homicide is murder. Culpable homicide is given in section 102. We'll discuss. what is will discuss what is culpable homicide and what is murder. In this case also there is a differentiation, distinguished in this case. So if the act by which the death is caused is done with the intention of causing death, or if the act by which the death is caused is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or if the act by which the death is caused is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or D, if the person committing the act by which the death is caused knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, or commit such act without any excuse for incurring the risk of causing death or such injury as aforesaid. This provision also having illustrations. So A shoots Z with the intention of killing him. Z dies in consequence. That it is directly applies murder here. So coming to B, illustration B. A, knowing that Z is laboring under such a disease that a blow is likely to cause his death, strikes him with the intention of causing bodily injury. Z dies in consequence of that blow. Then A is guilty of murder. Although the blow might not have been sufficient in the ordinary course of nature to cause death of a person in a sound state of health, but if A, not knowing that Z is laboring under disease, give him such a blow as would not in the ordinary course of nature kill a person in a sound state of health. Here A, although he may intend to cause bodily injury, is not guilty of murder if he did not intend to cause death or such bodily injury as in the ordinary course of nature would cause death. What we have to understand here is the intention to commit crime, and we have lot of interpretations what will apply, whether a accused offender having intention to kill him, whichever wherein he is having, the victim is suffering from any disease or not, what provision will apply. So whether he will be guilty of murder or not, this B illustration is very much clear. What is the course of nature here in this illustration? A was knowing that the Z is laboring under such a disease that if a blow cause his death, strikes him with the intention of causing bodily injury, then it will apply the provision of murder, punishment for murder 302 IPC. So if at all here given an exception, what is this exception is, but if A is not knowing that Z is laboring under a disease, gives him such a blow as would not in ordinary course of nature kill a person in a sound health of state of health, but in the here, although he may intend to cause bodily injury, that another provision will apply, causing injury to him. And in this illustration, if the offender is not having any intention to kill, or he is not having knowledge of disease of the victim, now although he may not have intent to cause bodily injury, is not guilty of murder if he did not intend to cause death or such bodily injury as an ordinary course of nature would cause death. So my only point is, the A might have knowledge, A with an intention to only cause bodily injury, that provision will, whichever provision will apply, will discuss. Now in this illustration, there is an exception. If A is having knowledge that he is laboring under such disease, knowing the disease, he caused bodily injury, then it will apply provision of murder. Another illustration, in B illustration, if the A is not having any knowledge of disease of victim, then the murder provision will not apply, but another provision will apply, which is causing bodily injury, and we'll discuss what provision, because we'll have to stick to time. So D, illustration C. We'll take some break. Coming back from the break, so we have read the B illustration. If A is not having any knowledge of the disease, then what application, what the provision will apply: hurt or grievous hurt, or voluntarily causing hurt, voluntarily causing grievous hurt, punishment for voluntarily causing hurt, whether criminal force will apply or not, we'll discuss in detail later on. So coming to the illustration C of murder definition 101 BNS. A intentionally gives Z a sword cut or club wound sufficient to cause death of a man in ordinary course of nature. Z dies in consequence. Here A is guilty of murder, although he may not have intended to cause death. So what is the meaning of this illustration? Again we'll read. A intentionally, Z gives Z a sword cut or club wound sufficient to cause death of a man in ordinary course of nature. Z dies in consequence. Here A is guilty of murder, although he may not have intended to cause this death. So A has intentionally caused injury with a sword, which is very much serious offense and which come under the definition of murder. And illustration D. A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them. Then A is guilty of murder, although he may not have had a premeditated design to kill any particular individual, because without any excuse, or firstly carrying a gun without any license itself is a crime, and moreover in the crowd what A did is he fired a loaded cannon into a crowd of persons, so and one was killed. It will amounts to murder. So there are exceptions to murder: exception 1 and explanation exception 2, exception 3, exception 4, exception 5, and further illustrations. And in this present case, coming back to our case, Sathakulam Custodial Death Case, what provision applied under section 302, and in the murder provision is section 300 IPC thirdly, because there are firstly, secondly, thirdly and fourthly. We'll come back to the provision of murder. Exception 1. Now we are reading thirdly in this case, where there is a judgment where Varsa Singh, namely, we will also discuss the judgment in detail, where in this judgment the Honorable Court, wherein sees that 4-part test, bodily, here in this case bodily injury present, its nature objectively determined, intention to inflict that injury, and sufficiency in the ordinary course of nature to cause death. So what happened in this case is beating inflicted with full knowledge of its likely fatal consequences. See, police, all the accused were having knowledge that they are causing bodily injury only based on their personal ego, maybe. So in this case, beating, all the accused have commonly, with a common intention, has beaten them. Both of them, individual roles are there. So two constables were held these two A and B victims. Then one accused were guarding the incident, the other one registering the FIR falsely. So in this case, provision applies is thirdly. What is thirdly in this? Further we will discuss. So we'll read from the IPC as well. Firstly, thirdly, we got this. In this case, thirdly applies. Murder, in IPC we are reading, except in these cases here and after accepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death, or secondly, it is done if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death. Intention of causing death of a person to whom the harm is caused. Thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Fourthly, if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commit such act without any excuse for incurring the risk of causing death or such injury aforesaid. So what is a culpable homicide? Culpable homicide is given in section 299. Whoever causes death by doing an act with the intention of causing death, with intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offence of culpable homicide. Illustration: A lays sticks and turf over a pit with the intention of thereby causing death and with the knowledge that the death is likely to be thereby caused. Z, believing the ground to be firm, treads on it, falls in and is killed. A commits the offence of culpable homicide, not the murder. A, illustration B, A knows Z to be behind a bush. He is having knowledge that B is behind the bush. B does not know. A, intending to cause or knowing it to cause be likely to cause Z's death, induces B to fire at the bush. A was having knowledge that B is behind the bush, but A having knowledge that B is behind the bush, he wanted to fire at the bush. So here B does not know. A knows that Z to be behind a bush. B does not know it. A, intending to cause or knowing it to cause, likely to cause Z's death, induces B to fire at the bush. Induces B to fire the bush. B fires and kills Z. Here B may be guilty of no offence, but A has committed the offence of culpable homicide, because B does not have any knowledge that B is not having knowledge that Z is behind the bush. So B fires and kills Z. Here B may be guilty of no offense, but A had committed offense of culpable homicide. It is what the meaning of culpable homicide, not amounting to murder. C. A. By shooting at a fowl with the intent to kill and steal it. A. By shooting at a fowl with intent to kill and steal it. He wanted to steal it, but kills B, who is behind a bush. Now, A was not knowing that B was present. So here, although A was doing an unlawful act, which is stealing by shooting at a fowl, which is an unlawful act, he was not guilty of culpable homicide here. Again, as he did not intend to kill B, he was not. There is again intention, or to cause death by doing an act that he knew likely to cause death. Explanation 1, 2, 3. For culpable homicide, a person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity and thereby accelerates the death of that other shall be deemed to have caused his death. Explanation 2. Where death is caused by bodily injury, the person who causes bodily injury that shall be deemed to have caused death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. Explanation 3. The causing of death of a child in the mother's womb is not homicide. The causing of death of a child in the mother's womb is not homicide, but it may amount to culpable homicide to cause death of a living child if any part of that child has been brought forth though the child may not have breathed or been completely born. And here intention and knowledge matters. So we'll all now why I am studying explaining here in brief is every provision will take lot of time to explain with relevant provision of law. So I am just briefly explaining it. Now coming back to the case, thirdly applies in this case where if the under provision of murder, if it is done with the intention of causing bodily injury, means all the persons having common intention and knows that bodily injury will be caused to any person and the bodily injury is intended to be inflicted is sufficient here in the ordinary course of nature to cause death. So all the accused were having knowledge that he is going, the two victims were beaten with lathis, and further it amounted to murder. Punishment for murder is, what is the punishment for murder? 103 BNS, 103 subsection 1 BNS. Punishment for murder which is non-bailable and non-compoundable. So 103 1. So punishment for murder, whoever commits murder shall be punished with death or imprisonment for life and shall also liable to be fined. Further 103(2) says, when a group of 5 or more persons acting in the concert commits crime, murder on the ground of race, caste or community, sex, place of birth, language, personal belief or any other similar ground, each member of group shall be punished with death or with imprisonment for life and also shall also be liable to be fined. In this case, custodial death case, it was concluded that this case is a rarest of the rare case. Rarest of the rare case. In the cases of rarest of the rare, guidelines which are to be kept in view when considering the question of whether the case belongs to the rarest of the rare category is Machi Singh versus State of Punjab, 1983, 3 SCC 470. In this case also, Varsa Singh case was discussed. What are the test was conducted to decide that whether the case comes under the category of rarest of the rare. And in this case, in the PPDs, I might have missed the constitutional article. What is the violations were committed by the accused. So, right to life under 21 of the Constitutional viewed. I am reading in the Bare Act, review of the death sentence cases in the open court. The fundamental right to life under Article 21 of the Constitution viewed in the light of irreversibility of the death sentence mandates that the review of death sentence should be in open court and not by circulation. Such a procedure for review of death sentences cases is in compliance with the principle of due process of law, is just, fair and reasonable, which would not be so if review by circulation is adopted instead of such oral hearing. So we'll discuss again. We'll discuss every single word has its own meaning and provisions. Coming back to the case, thirdly applies, and the Madurai Sessions Court had applied the Varsa Singh 4-part test. Bodily injury presents, its nature, its objects determined, the intention to inflict the injuries caused to the victims A and B, and what sufficient to charge them under these provisions. So coming to we have not completed this entire provision. We only discussed the particular provision, what caused the whether murder applies or not. So in this case, murder was applied. Provision section 127 subsection 2 section 103 subsection 1 BNS for the accused murder on 2 counts, accused number 2 to 7 and 9. 342 IPC 127 subsection 2 BNS of wrongful confinement on 2 counts, all the 9 accused. 238 for false evidence and causing disappearance of the evidence, false information on 2 counts, all 9 accused. So in 302, punishment for murder on 2 counts, accused 2 to 7 and 9, not 8, not the accused number 8. So again, what happened here is section 302 IPC Red Wing 34, which is again murder was applied. So coming to the next provision of law is 109 IPC, which is 49 BNS, read with 114 IPC, which is 54 BNS. The chapter is of abatement. What is abatement here? Given in 49. We'll read firstly what is abatement. Chapter 4 of BNS of abatement, criminal conspiracy and attempt. We are only confined here of abatement only. Section 45, abatement of a thing. Abatement means what? A person abets the doing of a thing who instigates any person to do that thing. Instigation to doing such a thing to another person is abatement. Also engages with one or more other person or persons in any conspiracy for the doing of that thing if an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing, or intentionally aid by any act or illegal omission of the doing of the thing is abatement. So explanation 1, a person who by willful misrepresentation or by willful concealment of a material fact which is bound to disclose voluntarily causes or procures or attempts to cause or procure a thing to be done is said to instigate the doing of the thing. We'll read with examples, illustrations, and relevant citations also. So, a public officer is authorized by a warrant from a court to apprehend Z. A public officer is authorized by a warrant from a court to apprehend Z. Now, B, knowing the fact and also that C is not Z, willfully represents to A that C is Z, and thereby intentionally causes A to apprehend C. Here B abets by instigation the apprehension of C. He wantedly, intentionally done this act. Whoever, we have explanation 2, whoever either prior to or at the time of commission of an act does anything in order to facilitate the commission of that act and thereby facilitates the commission thereof is said to aid the doing of that act. So, abatement, to constitute abatement, there must be a course of conduct or an action of intentionally aiding or facilitating another person to end life. Example, in this case only, what the prime accused has done, he instigated the another co-accused to disappear the evidence, to delete the CCTV footage. Live example is, the prime accused, what he has done is, he instigated, he directed their colleagues, co-accused, to delete the CCTV footage. That itself amounts to abatement. And another, what other accused had did, they held the victims. Another one, the other accused, co-accused, beaten them. All this was done under the guidance of main accused. That is called abatement. We have read the meaning of abatement, where in this case the inspector did not personally strike the most of the blows, but repeatedly instigated the rounds of beating, instigated the co-accused to beat the victims. That is where abatement comes into picture. So we have what the provision is 109 49 BNS. So we'll read the 49 BNS. Punishment. Punishment of abatement if act abated is committed in consequence and where no express provision is made for its punishment. Again we'll read. Punishment of abatement if act abated is committed and in consequence and where no express provision is made for its punishment. So whoever abets any offense shall, because see again, in this criminal law jurisprudence we have to understand one single word also. Shall, may, must, and other words also I will discuss. Firstly, will shall and must and may will have to understand in detail. So coming to the 49 section, whoever abets or any offense shall, comma, because comma also matters in these provisions. Commas also having its own interpretation in criminal law jurisprudence. Whoever abets any offense shall, if the act abated is committed in consequence of the abatement, comma, and no express provision is made by this Sanhita for the punishment of such abatement, be punished with punishment provided for the offense. Explanation: an act or offense is said to be committed in consequence of the abatement when it is committed in consequence of the instigation or in pursuance of the conspiracy with aid which constitutes the abatement. So, an instigator is punished as if he had committed the act himself after instigating someone, because common intention also applies here. So, Illustration: A instigates B to give false evidence. B, in consequence of the instigation, commits that offence. A is guilty of abetting that offence and liable to the same punishment as B. Both will be punished. A and B conspire to poison Z. A, in pursuance of the conspiracy, procures the poison and delivers it to B in order that he may administer it to Z. B, in pursuance of the conspiracy, administered the poison to Z in A's absence and thereby causes death. Here B is guilty of murder. See, again, murder applies here in this illustration. B is guilty of murder. A is guilty of abetting that offence by conspiracy and is liable to the punishment of murder. Because common intention applies, conspiracy applies, because they have conspired, and in this case also we'll read. So another provision, 114 BNS, murder or alternatively abetment. Accused 1 and 8 only were charged for abetment. 54 BNS. 54 BNS is abetter present when offence is committed. Whenever any person, who is absent, any person who is absent would be liable to be punished as an abettor, is present when the act or offence for which he would be punishable in consequence of the abatement is committed, he shall deem to be have committed such an act or offence. For example, A, what he has done? He informed that B has to commit murder or shoot C, and B goes to C and fires him with a gun and committed murder. A was not present at the site, so A is abettor, so he will also be punished as B is punished. A has committed abatement of murder. In this case also, Z, the main instigator, main accused, he did not strike most of the blows with lathis or by human beating. So he did not, main instigator, he did not, because here abatement is applied only to accused number 1 and 8. So what they did is they abetted this crime to other co-accused to beat the victims. That is where abatement comes, and what definitions of we learned section 49 and section 54 is abatement. We have already understood with the illustrations. And small example, again we'll read the illustration. A instigates B to give false evidence. B, in consequence of the instigation, commits that crime, and A is guilty of abetting that offence and liable to be same punishment as B. So we'll also learn in this case itself classification, provision mapping, what provisions applied in this case, what is the evidence, when the evidence will apply, when the CRPC will apply, BNSS will be applied, what are the articles of the constitutional, because we'll have to learn constitutional as well, whether human rights violated or not. Coming to the next provision, the punishment also we'll learn in the coming slides, because session is going long, and these only for criminal law, only for IPC we have to learn a lot of things with the provisions. It will take many sessions, many classes. So we'll conclude as soon as possible the remaining sections only for IPC, and remaining because this Sathakulam Custodial Death Case will take long time to explain the IPC, CRPC and evidence along with the BNS, BNSS and BSA evidence. So coming to the section 195 of IPC, the 231 BNS, fabricating the false evidence for a more than 7 year offence. We 107 is definition. 107. Again, we have missed one thing. Wait, of abatement is 107, 109 definition. 109 APC is here. One more provision is 55 BNS. What is 55 BNS is? We will read in detail 55 BNS. BNS is abatement of offence punishable with death or for life. So we will read only relevant sections in this case, and remaining sections will conduct during our particular classes of criminal law, IPC, CRPC and evidence. And we have to study, because in the judicial examinations we have to study the IPC, we have to study all the individual laws, civil law, criminal law, family law, Hindu law. So now coming to the next section is 231 BNS. Session is going too long. Everyone will get bored, because again the session is 61 minutes for now. We'll divide into two parts. Section 231 BNS. 231 BNS is giving or fabricating false evidence with intent to procure conviction of offence punishable with imprisonment for life or imprisonment. Giving or fabricating false evidence with intent to procure the conviction of a person for an offence punishable with death, life imprisonment or imprisonment of 7 years or more. So whoever gives or fabricates, fabricating means creating evidence. Whoever gives or fabricates false evidence intending thereby to cause or knowing it to likely that he will thereby cause any person to be convicted of offence. Because in this case the police have registered false case against these two victims, so that they created the evidence so that they will be punished and convicted under that crime. So this section 231 of BNS will apply, where they gives or fabricate false evidence intending thereby to cause or knowing it to be likely that he will thereby cause any person to be convicted of an offence which by the law for the time being in force in India is not capital but the punishable with imprisonment for life. Here this very serious provision is very serious crime. Imprisonment for life or imprisoned for a term more than 7 years or upwards shall be punished as a person convicted of that offence would be liable to be punished. So here in this case this provision which clearly applies, where they have created the evidence, fabricated the evidence, false evidence so that the A and B will be punished. But it got reversed, and these persons were who was convicted. 1, 3, 4 and 6 were convicted under section 231 BNS. Illustration is A gives false evidence before a court, because in the next slide there is a illustration also for giving fabricating evidence. A gives false evidence before a court, intending thereby to cause Z to be convicted of a dacoity. Dacoity is another offence that is comes under IPC. Again, we have to read that section. We have to go to dacoity section again. So, the A gives false evidence before a court, intending thereby to cause Z to be convicted of a dacoity, because this clearly applies. In the next slide we will learn. A gives false evidence before a court, intending thereby to cause Z to be convicted of a dacoity. The punishment of a dacoity is imprisonment for life or rigorous imprisonment. Imprisonment will learn for a term which may extend to 10 years or with or without fine. A therefore is liable for imprisonment for life or imprisonment with or without fine. In this case, after conducting of thorough trial, the honorable judge will decide under which the accused will be convicted, whether it will be convicted under he will be convicted for life, imprisonment for life, or will decide under how many years will apply, like whether 7 years or 10 years or imprisonment for life based on the evidence, based on the trial. So 231, for fabricating false evidence. What the accused, what the convicted persons have fabricated, what evidence has they have fabricated will show. So coming to the next section, which is 248 BNS. 248 BNS. What is 248 BNS? 211 IPC. Yes. Coming back to this 231, fabricating false evidence. What evidence they have fabricated is Exhibit D18 bearing an anachronistic date of 2024 to secure conviction of an offence punishable with 7+ years. They have fabricated a document showing the date of 2024 when the crime was committed in the year 2020, because they have also died, the accused in the alleged crime died in the year 2020 itself. So next, coming to 211 IPC, 248 BNS, read with 34 IPC. 248. False charge of offence made with intent to injure. Whoever with intent to cause injury to any person institutes or causes to be instituted any criminal proceeding against that person, or falsely charges any person with having committed an offence, knowing that there is no just or lawful ground for such proceeding or charge against that person, then they shall be punished with imprisonment of either description for a term which may extend to 5 years, or with fine which may extend to 2 lakh rupees. 5 years, 2 years, 5 years with fine which may extend to 2 lakh rupees, or with both. If such criminal proceeding be instituted on a false charge on offence punishable with death, imprisonment for life, or imprisonment for 10 years or upwards, shall be punishable with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. There are 3 subsections, clauses. So in this case, one of the head constable who is the accused lodged a false complaint. There was no offence committed by 2 persons. That was concluded by the Sessions Court that no offence was committed. In this case, one of the constable lodged a false complaint against these 2 victims, instituting a criminal proceeding known to be false, because there is nothing. They created and lodged an FIR with the intent to cause injury to these persons. So, false charge of an offence made with intent to injure, institution or causing institution of criminal proceeding known to be false will applies to this case where this punishment is which may extend to 5 years or with fine, or with either which may extend to 10 years also. Coming to the section 218 IPC 256 BNS. 256 BNS. The chapter comes under against public justice, because this of false, chapter 14 of false evidence and offences against public justice. 256 public servant framing incorrect record or writing with intent to save a person from punishment of property from forfeiture. So, whoever being a public servant and being such a public servant charged with the preparation of any record, or writing, other writing, frames that record or writing in a manner which knows to be incorrect, with intent to cause or knowing is it to be likely that he will thereby cause loss or injury to the public or to any other person, or with intent thereby to save, or knowing it to be likely that he will thereby save any person from legal punishment, because the police, 9 police will help each other to get away from the punishment, or with intent to save or knowing that he is likely to thereby to save any property from forfeiture or other charge to which it is liable by law, shall be punished with imprisonment of either description for a term which may extend to 3 years. 3 years provision, 3 years is bailable. Some provisions might be bailable, not bailable. In this case, with fine or with both. And also we'll discuss, because it will take a lot of time. Again, I'm saying this. Bailable offences, non-bailable offences, compoundable offences, non-compoundable offences. We have to read what is compoundable offence, what is non-compoundable offence, what is bailable, what is non-bailable. Again, it will take another long time, so we'll discuss in another class later. Because why I am sticking here, why I am confining myself to short briefs is we'll have to learn in detail. There is no exception, there is no escape, because so we'll have to learn. Okay. Now coming to the 256 218 of IPC, what happened is the accused altered entries in the police station's general diary and duty registers, which was later after identified by the handwriting and ink analysis. Again it is a huge large discussion. So, a public servant framing an incorrect record or writing with an intent to save any other person co-accused from legal punishment or lawful property forfeiture. Next is today again we'll what are the CRPC provisions and the evidence and the constitutional what is the articles applies in this case because of the human rights violation. So we'll discuss this later. Now 6 converging pillars of proof. In this case, so now we have only seen the provisions of IPC. So what happened in this, what are the evidence seen in this case is, just a moment. We have read now all the provisions. What is the provisions? 342 IPC, 127 2 BNS, 238 BNS, 103 1 BNS murder, uh, abatement, fabricating false evidence, instituting a criminal proceeding to injure public servant, framing an incorrect record to save another person. 6 converging pillars of proof. So, number 1 is direct eyewitness testimony. Direct eyewitness. Based on this direct witnesses, this is one part of witnesses, and there are another evidences now we are discussing. Major conviction was there, where there were 2 on-duty constables present on that night because they were helpless, women constables. Direct eyewitness testimony was given by 2 duty constables present through the night. Number 2, CCTV and digital timeline analysis. CCTV and digital timeline analysis. Second by second reconstruction, corrected clock offset. Because nowadays the Honorable Supreme Court made it clear that every police station must have, there is no escape. All the police stations have to install CCTV cameras, and it is a public record. But no one will follow. In this case, CCTV was erased. Again, that provision also applies in this case for committing that crime. Number 1 is direct eyewitness testimony. Number 2 is CCTV and digital timeline analysis. Number 3, all the 6 pillars of proof are very important in this case and have huge impact. Number 3 is forensic and DNA evidence. So, blood stains, their clothes, because clothes were removed during beating. So, blood matched the across scene, the weapons and the victims. Number 4, medical evidence. There were 2 independent panels, video recorded post-mortem, because many of the cases earlier there used to be time where there were no video recording of the post-mortems, because nowadays what is happening is during that crime everyone can escape. They can destroy the evidence by hand in glove with the witness, this post-mortem of. So, medical evidence is 2 independent panels were there. The post-mortem was video recorded. See, this is the rarest of the rare case. In many of the cases, no post-mortem will be video recorded. And I think from this case, it will be very beneficial to the prosecution also, and to bring the accused under conviction. Video recorded post-mortem. Number 5, dying declarations. So, what dying declaration happened in this case is, during under trial statements of fellow under trials before death, they were died later on. The under trial prisoners gave evidence before the court about this incident, what happened during the incidents before the death of the 2 victims, A and B, father and son. Statements was given by the under trial prisoners. Number 6, documentary cover-up evidence. They have covered up the evidence. False FIR registered, that is documentary evidence. Again, see, evidence will read in the another classes. Documentary cover-up evidence is false FIR. Firstly, false FIR. They altered the registers without any valid reasons. without any permissions maybe, and discarded the clothing. They discarded the clothing of the victims. So this is the heinous crime committed by the all 9 accused. 10th accused was died. 10th accused was died during the investigation. So these are the 6 converging pillars of proof we have understood, because these 6 having another, all the provisions coming applies in the Evidence Act, and also CRPC applies. Direct evidence testimony, how to what is the procedure for recording the witnesses. So what is the procedure to DNA evidence, forensic evidence, what are the dying declarations, what are the documentary evidence, and registration of FIR, which provision applies. So coming to the next, eyewitness testimony and CCTV analysis. As discussed, prosecution witness number 44, who was the station clerk, present until 9 p.m. because of the duty. 9 p.m. witnessed the initial beating of these accused against the 2 victims, A and B. So PW 44 was there at the 9 p.m. because might be unhelpful, because couldn't help to stop the crime. So another one is PW 47. Present PW 47, prosecution witness 47, number 47, present from 8:50 p.m. until morning, gave the most complete account, including the main instigators, the false complaint, and the order to arrest CCTV. Because of the seniors' instigation will not be helpful. They cannot escape from the duty, otherwise they will also be included in this alleged crime. And the same was direct eyewitnesses was corroborated by the PW 20, prosecution witness 20 and 26, and a civilian witnesses who heard the beating from outside, because it was a heinous crime. It was evidenced by many persons. There are as many as witnesses examined and cross-examined. CCTV analysis. Now, in the CCTV analysis, second by second reconstruction from a neighboring shop CCTV, correcting a verified 2 hour clock offset, cross-checked against sunset time, because this police station CCTV was arrested. They wanted to escape, but they cannot escape from neighboring CCTV footage. So here showed this CCTV footage of the neighbors showed A walking calmly, uninjured at 7:48, 3:38 p.m. Uninjured, walking calmly, uninjured at so and so time, before the alleged curfew violation could have occurred. He was walking calmly, uninjured. That was the CCTV showed that. And the police station's own CCTV hard disk had no footage for the relevant 10 days. They have erased an entire the hard disk. They discarded. So here in this case, applying the section 106 of Evidence Act, the court held that burden shifted to the accused to explain the gap, which they failed to do, obviously. So coming next, we'll read evidence provisions. Now, forensic DNA and medical evidence, as earlier discussed in the above. 20 blood sample locations at the police station. There were 20 blood sample locations. See how heinous crime is this. 8 blood sample locations at subjail cell. 18 injuries recorded on each body by the postmortem board. The accused tried to discard all evidence. They want to fabricate, they want to disappear the evidence, make the disappearance of the evidence. But there were locations, blood sample locations at the police station, the sub-jail jail, and there were 18 injuries recorded on each body by the postmortem board. Now postmortem, another word, postmortem. Again, there is a huge discussion on postmortem and what are the procedures of the postmortem, whether it should be video recorded or not. Again, we have to go into depth. Why I am discussing here is, in the judicial examinations, we don't know from which provision, from which explanation, from which exception, from which illustration in the preliminary examination will come, in the mains examination will come, during the interview what they will ask. Unless we study, unless we examine all the provisions in detail, one by one, it will take a lot of time to explain the provisions. I will do it at any cost. How much time it will take, I will discuss in detail. I am also building a team. It will take some time to me to build a team to take the classes of IPC separately, CRPC, evidence, civil laws, family laws, and other laws which were already discussed in the earlier sessions. Please, you also examine all the aspects of criminal law, evidence, in civil law, contract law again. So now what happened here in this DNA evidence, Central Forensic Science Laboratory, New Delhi, matched the blood on the police station walls, floor, seized lathi and a calendar in the inspector's room to blood on the victim's own clothing and to a reference sample from A's widow, closing the forensic chain. See, again, they have matched the blood samples from station walls, floor and cellular jail, sub-jail. Matched the blood samples. That is DNA evidence. Now medical evidence and DNA evidence. A huge discussion again. Medical evidence. A video recorded postmortem board and a multi-institutional medical board, AIMS and senior forensic doctors both found the injuries cumulatively sufficient in the ordinary course of nature to cause death from delayed complications of hemorrhagic shock. It was neither found negligence by treating doctors or jail officials. So every single aspect of crime committed, every single evidence and the procedures, disappearance of the evidence has taken into consideration for conviction of these accused, 9 accused, because in many cases not everyone can escape from the crimes. This is the rarest of the rare case where 9 accused were convicted to death. Death sentence was pronounced. Dying declarations number 3, evidentiary framework. So we have seen the eyewitness testimony, 6 pillars of proof, eyewitness, CCTV analysis, forensic evidence. Now we are going into dying declarations and the documentary cover-up, what they have done. Dying declarations. Fellow under trial prisoners who are PW 17 and PW 46 and others testified that A and B, father and son, told them before dying that Sathakulam police station had beaten them. Yes, this aspect was also taken into consideration for conviction. And one more thing, this judgment by the Sessions Court is about 683 pages in Tamil language. It took me lot of time to translate it into AI. Claude AI, I have used Claude AI to translate from Tamil language to English language. I have translated through AI. I have translated this, that came down to 243 around pages. Out of 243 pages, again I have made this summary. So now coming to dying declaration, PW 1746 testified that A and B, father and son, have told them before dying that the police have beaten them. The court treated these dying declarations as carrying significant evidentiary weight, and one of the independent victim of similar treatment, see here, similar, because these particular police station had habitual custodial violence. So this one of the person was a victim of similar treatment by the same officers in the unrelated case. So this was considered, and documentary cover-up is firstly a false FIR was registered inconsistent with the CCTV timeline, alter the entries in the station's general diary and duty registers, identified through handwriting and ink analysis, blood-stained clothing discarded in the station's rubbish, later recovered by the forensic teams. Blood-stained clothing was discarded, so they later recovered by the forensic teams. A private vehicle also confiscated, not official one, because police have to use every time official vehicle to transport the accused to judicial custody. They used transport this private vehicle to injured men to jail. Next, here, murder or culpable homicide. Again, section 299 IPC, 300 and 302. 300 is murder definition, explanations, and 302 is punishment for murder. I have discussed this Varsa Singh versus State of Punjab, AIR, All India Report 1958, Supreme Court 465. Section 300, murder is the third part of the provision applied in this case into 4 ABCD, the Varsa Singh test, 4-part test. Firstly, to apply to whether to decide murder or culpable homicide, we have to use this judgment Varsa Singh versus State of Punjab, AR 1958 SC 465 test, under section 300. Thirdly, a bodily injury exists, yes or not? There was a bodily injury. B, the nature of that injury objectively determined. What are the nature of injury? They have beaten with the lathi. They have caused many as injuries on the body of 2 victims. Number C, the accused intended to inflict the particular injury, not necessarily death. The accused intended to inflict that particular injury. D, the injury was objectively sufficient in the ordinary course of nature to cause death, as we discussed in the detailed discussion in the murder provision. So, application and holding, what happened, how it was applicable. So, State of Andhra Pradesh versus Rayavarapu Punnaya, 1977, 1 SCC 601. Cumulative injury from an ordinary weapon by multiple assailants may still constitute murder, absent of a specific intention to kill. See, injury from an ordinary weapon by multiple assailants may injury from an ordinary weapon, one weapon is used by multiple assailants, may still constitute murder, absent of a specific intention to kill. It was held that the sustained repeated hours long beating inflicted with the full knowledge of its likely fatal consequences, it was satisfied that the test for murder, not culpable homicide. because culpable homicide is different, as we discussed in this session earlier, in the above session, previously, it not applied the culpable homicide. It was applied the murder only, not culpable homicide, because there was an intention to beat them, they tortured them, they instigated the other accused. One was guarding, one was holding the two victims. So in this case, the same was applied in the case, and four part test of thirdly of section 300 IPC murder to decide whether murder applies or culpable homicide applies. Again, here I am again going into detail. Farsa Singh versus State of Punjab, State of Andhra Pradesh versus Rayavarapu Punnaya. We will discuss this judgment in the another session. So coming to the next part, section 106, burden shift in custodial deaths. Now coming to the 106 evidence. Section 106 evidence is Section 106 Evidence Act applies to both civil and criminal laws. Burden of proving fact, especially within the knowledge. When any fact is especially within the knowledge of any person, when any fact is especially within the knowledge of any person, the burden of proving that person is upon him. When any fact is especially within the knowledge of any person, the burden of proving the fact is upon him itself. Illustration is when a person does an act with some intention other than which the character and circumstances of the act suggest, the burden of proving that intention is upon him. Example, I am facing some accusations. In this case, we will take the live example. For example, we'll take the live examples of this case only. Illustration is a charge with traveling in a railway without ticket. Now, this is another illustration. A is charged with traveling in a railway without ticket. Without ticket, I am traveling. For example, TC will comes and ask for the ticket. What will I have to do? I have to show the ticket. If I am not having, I have to prove it that I am having ticket by giving the ticket showing the ticket to the TC. If I am not having any ticket, it means I am violating the rules. I have to pay the fine or face the consequences. So the burden of proving that I am having a ticket is on me. This is the illustration. Coming to the in the custodial death, shift the burden, the onus shift on the accused itself, not the victim. So in this case, custodial circumstances, I am reading the sentence, because custodial circumstances are peculiarly within the knowledge of the police. Once the prosecution established that a person died in the police custody, the evidential burden shift on the police itself to explain how the death is occurred. They have to explain in detail why and how the death is occurred in the police station, how the custodial death happened, why it was happened. So there are some judgments which were discussed in this 683 page judgment. Is Munshi Singh versus Gautam versus State of MP 2005, 9 SCC 631, KH Shekharappa versus State of Karnataka 2009 SCC, Bhagwan Singh versus State of Punjab 1992 3 SCC, State of MP versus Shyam Sundar Trivedi, and State of UP versus Ram Sagar Yadav. These are the relevancy of this judgment with regard to evidence. And what happened there is, because the accused did not able to show, they cannot explain, because all the evidence DNA, CCTV matched the crime. So the accused silence or failure to explain in the section 313 accused CRPC statements was treated as an additional link in the chain of circumstantial guilt. So next, another, the false FIR, evidence destruction and the alibi. In the another slides, there are a lot of slides in this PPT with regard to provisions of evidence. I will come next. I'm only discussing the case because I have already covered the IPC provisions. So I have to cover pending is this CRPC and evidence. So IPC, what are the IPC provisions we have covered in this above. The false FIR, evidence and destruction and alibi. The false FIR, court held that false case occurred at the police station, so the remedy could be perused there to ubi just ibi remedium. What is this legal maxims? Again, legal maxims classes will be conducted in detail. So further we see is what is mean by ubi just ibi remedium. Means where there is a right, there is a remedy. If I'm having a right, where there is a right, there is a remedy. That is a legal maxim which applied in this case also. So these legal maxim establishes that every legal right must have an enforceable remedy. So what happened in this case is the police registered a false case, so there is some remedy to the victim. The court thereafter distinguished defense precedent, no separate trial had conducted. This is very important. The court distinguished defense precedent, no separate trial had conducted on crime number 321/20, which was a false case against the accused. So no double jeopardy bar applied here. Next, evidence destruction. Section 201, CCTV erased on SI's conduct, SI's order, bloodstained clothing discarded in a private vehicle used to avoid bloodstains being seen. It was held that even a failure to seize evidence, not just destroying it, can offend 201 of IPC where intended to shield the accused. The alibi. So, accused taken the plea of alibi. What is alibi? We'll read again. We'll have to show you, right? There is the doctrine of alibi also. In the Evidence Act, plea of alibi. Alibi means elsewhere. A crime was committed, a robbery was committed, for example. Robbery was committed at a place, and I am not present at the place of crime. I am elsewhere. For example, a robbery has been committed in the bank by some people. I am at another place, for example. So, the police had included my name in the FIR. When I am not at the place of crime, at the crime scene, then alibi, I can take the plea of alibi. So in the simple terms, I have explained this. The plea of alibi was rejected in this case by the Sessions Court. So they presented 7 COVID patrol encounters, each with a photocopied Aadhaar card, None were independently corroborated. Exhibit D18 bore an anachronistic 2424 date. Court found fabrication and ordered separate proceedings for false evidence. See, very much important in this case, false evidence also they have charged. Now, the verdict, what happened in this case, because we have to continue with the this verdict will be discussed in the final session of this series, this IPC series, criminal law series. So I'm only on today in this today's class, and I have divided into 3 parts, 30 minutes, because already 100 minutes class is recorded. So this verdict and provisions of CRPC and Evidence Act will be discussed in the next part. So coming forward, the verdict, sentencing, rarest of the rare case, topic, precedents, what are the judgments, what is the significance, critical observations, and MCQ practice will see, we'll all discuss the question number MCQs also. I have made this for understanding easily. We'll also learn with the MCQs. We'll create the question bank to all the now questions and discussion, because some of the slides we have discussed only till 14 slides in this PPT. Now 15th slide is the verdict, and thereafter the IPC and CRPC, the CRPC and evidence provisions in the next classes. The verdict, sentencing, the remaining slides from 15 to 44 along with the multiple choice questions we'll discuss later. Today I'm concluding it. So till 14 slide. Questions and discussion. We always welcome your thoughts and questions, suggestions, review, whatever your feedbacks. You can send me to my personal email ID, masalegarlegalclinic@gmail.com. We look forward to hearing from you, and thank you for having patience of listening to my class, because these classes are taking so much time to me to record, pre-record. We will also conduct live classes later, because you have to understand, many people are becoming thinking that these classes are bore. Will think that they'll get bored, but I don't want to bore all of you, but only I want to make it clear that I'm only doing these classes for the purpose of educating young lawyers, youngsters, law graduates who are pursuing LLB as well. They can also watch these videos. It will be helpful for them to understand the criminal laws and other laws. My only core intention, my only main intention to post this on YouTube is so that many people will learn, because of the affordability. This is the free classes which will be free on YouTube. So when we launch our coaching institute official these physical classes, then we'll see what we'll have to do. So I'm very thankful to Almighty, and I'm also learning with you all guys, and my only intention to educate and encourage the young lawyers. These classes also include the legal clinic work also, so that you can learn the criminal laws in detail, in depth. So we'll also have practical knowledge how the law applies, how the courts work, what we'll do in the courts. Nothing, people don't know many things and directly joining courts, directly going to courts. So I will discuss, already I've discussed in the earlier sessions also, that will encourage the youngsters, young lawyers who are the fresh graduates to practice, encouraging the practice in the trial courts first. Then we'll go to the high court, or in the cities we'll have high court and the trial courts as well. So it will be easy for them, and the Supreme Court. And when to do the internships, when to join the internships, we'll do everything. And thank you very much for your patience. And this video have come to 109 minutes and took a lot of hard work and research. Thank you very much.